Okay, Chapter 4, Contracts for International Sale of Goods. The big picture. The UN Convention on Contracts for International Sale of Goods and related topics such as transportation, i.e. Incoterms, and payments are absolutely vital part of your studies. They always come up in exams, in one question or two sometimes. So you must look at this, certainly in your lectures and on your notes. You've got to learn and prepare to give definitions of key terms. Not difficult definitions. Again, it's just the volume of them and remembering them under exam situations. You must also be able to, in context of contracts for international sale of goods, be able to apply your knowledge of the rights and obligations of either buyers and sellers, or maybe both. Okay, sometimes the examiner puts it one way, what's the buyer's right, sometimes it's the seller's rights. They might lay out a scenario where something's gone wrong and then leave you to apply your knowledge. You should note carefully that the Convention on CISG only applies to the sale of goods and does not apply to supply services. Okay, so it's not supply services or contracts where the buyer provides the majority of materials, meaning that this obligation of the seller is again provision of labour, so supply services. Okay, it's formed where there is a proper acceptance of a valid offer. You need to have acceptance and you need to have offer to make up a proper contract. You should not have an invitation to treat, which is almost like where in the shop window you are invited to come in and buy. So it's not a valid offer. It's not the same thing. Okay, so what is an offer? It's a term you must learn, but basically an offer is a proposal for concluding a contract addressed to one or more specific persons that is sufficiently definite and indicates the intention of the offeror to be bound by the acceptance. Okay, so that's what an offer is. In this context, sufficiently definite means the goods are identified, the quantity of goods is identified, and the price you're going to sell them at is clearly identified. There must be no ambiguity, otherwise it will not be a valid offer. An offer does not need to be in writing because it can become effective when it reaches the offeree and may be ended in the following ways: withdrawn, revoked, or rejected. The offeror can do either of those, okay, to end an offer. Okay, that's the offer side. What about acceptance? Acceptance may be indicated by word or action, so it doesn't again have to be in writing. Acceptance can also, however, be withdrawn, but to be withdrawn, it can only be withdrawn if it reaches the offeror, the person who made the offer, before or at the same time as the acceptance would otherwise have been effective. So sometimes the examiner will lay out timings of a certain scenario and you've got to work out whether there's a valid acceptance and or withdrawal. If an offeree, the person who's been offered, makes an amendment to the original offer, this is known as a counter offer, and this again can form an important part of a question, particularly a scenario-based question. Minor amendments can be effectively still be treated as accepting, subject to the offerer's right to reject within a reasonable time. Major amendments constitute a counter offer, so it's something to look for in exams. Is it minor or major? And again, it depends on the facts, and the examiner will try and make it fairly obvious. Incoterms, I believe these are changing all the time, but there is a standard list which I'm about to reveal now. You do need to learn these. Unfortunately, there is no easy way other than to keep writing them down and learning what they mean, and be able to briefly describe and explain the meaning of each of them. And the examiner might even just ask you to name a couple of them, like what is FOB, what is FAS, and you just need to either know it or you don't. Main rights and obligations of buyers and sellers. Key part of an exam question. They'll often do the buyer's rights or the buyer's obligations. If the seller is in breach of contract, i.e. they have not fulfilled their side of the bargain, the buyer may, depending on the level of the breach, they have the right to require performance, i.e. see the contract through, have the contract avoided, i.e. comes to an end. They could obtain a price reduction, obtain damages to mitigate their loss. Obtain damages, but they can't claim everything and anything. They do need to mitigate that loss. They can't just have anything and everything. The buyer's obligations is to, where possible, check the goods for conformity as soon as possible after delivery, i.e. is it the right price, quality and quantity. They accept delivery of the goods at the agreed place, destination in the contract. They must make payment of the goods at the right time as per the contract, and where necessary preserve the goods in the state that they require them to be in accordance with the contract. Seller's rights, the other side of the fence if you like, is the buyer will be in breach of their contract in certain ways. Payment and acceptance of the goods is something they must fulfill. They can have the contract avoided, and again they can obtain damages, the seller, if the buyer is in breach of the contract. Seller has obligations, however, that they must effect delivery of the goods at the specified place as agreed per the contract, or in accordance with the convention, wherever that will be. They must ensure the quality and the conformity is upheld. In other words, if they've given a sample, then all the other goods must be of the same level and standard. They must ensure the goods are free of any other charges held by third parties, and again, when necessary, they must preserve the goods in a state that is expected of the agreement. Passing of risk is a significant point within an application type question, as it links the Incoterms. It helps to explain which party will be responsible for insurance of the goods as they move in transit, from particularly on a ship. The key points to note are: if the contract involves carriage, then unless specified otherwise, risk only passes when the goods are handed to the first carrier. If the contract does not involve carriage, unless specified otherwise, risk passes when the goods are taken over by the buyer. So the first one, first carrier; second one, only when the buyer takes the goods. Transportation documentation is an important part of the syllabus. A bill of lading is the documentary evidence that the goods have passed to the carrier. So it's almost like a title deed of a property. Usually the bill of lading can be negotiable or non-negotiable, even while it's on transit. The goods are on transit. There are 4 types of lading: inland, ocean, through, airway. I would suggest that you look at those in the essential text online. Payments. Payments for goods can be done by international bills of exchange or a bank transfer. Bills of exchange are different, where a bank transfer is just simply one bank account paying another bank account. Bills of exchange is something the bank will honour before the goods leave. for their destination. Letters of credit should not be confused with a letter of comfort, which is issued by a parent for a subsidiary. International bills of exchange are subject of Unilateral Convention, which basically means that they are defined as a written instrument which contains an unconditional order where the drawer directs the drawee, i.e. the people's banks, to pay a definite sum of money to the payee. It's payable on demand, is dated and is signed by the drawer. In other words, what we're saying is, before the goods have even left for the other side, both sides know who's going to pay and who's going to, which bank and when and how, and it's guaranteed, and makes the vendor or the seller feel more comfortable they're going to get paid for the goods that they're moving across international waters. International bank transfer, subject to the model, it provides terms and rights under which the buyer must transfer the funds to the seller through the banking system. A letter of credit takes a variety of forms, again essentially provides the seller with a guarantee of payment. Involves a beneficiary having a issuing bank, a buyer's bank, and advising the seller's bank. So it's all set up in front of the contract and the goods have not yet left. It's all to create certainty across borders, because one of the hardest things about international trade is, will you get paid? Okay, that's the end of that chapter. We'll see you in the next chapter, chapter 5.